Welcome to this free immigration help channel. Today is August 8th, 2023, and we are getting into the volume 146 of me answering your immigration related questions. As always, before beginning this video, I'm gonna mention, as I mentioned in every video on this channel, I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question from Sujan Kunwar 8643. Hi, my priority date is August 4, 2021. I am in F2A category. It's been already documentarily qualified on February 14, 2023. Do you know when can I get my interview? Thank you. Sujan, thank you very much for your question, your comment. Really appreciate it. So F2A category, as we know, on August edition of the visa bulletin, it did retrogress quite a little bit. So there's definitely going to be some additional time waiting. Now you didn't specify your chargeability area, so I'm going to look at all chargeability area. Let's take a look at the visa bulletin for August 2023. Since you are already documentarily qualified, we're going to be looking at graph A, final action dates, F2A, all chargeability right here. It is showing as of right now, as of August 2023, as the most recent visa bulletin edition, October 2017, which means that people with priority dates back in October 2017, as of right now in F2A category in all chargeability area, from all chargeability area, meaning the rest of the world, besides China, India, Mexico, and Philippines. Although, as you can see, China, India, and Philippines are same with the rest of the world. It is showing October 2017, and you are in August 2021, so roughly looks like 4 years you have between what is showing right now on the visa bulletin and your priority date, for your priority date to become current. Roughly 4 more years. Now, since you were already documentarily qualified, most likely, because you were documentarily qualified in February 2023, and back in February 2023, we were still on, I think we were like on 2020, 2021, I think, if I remember correctly. Let's take a look, because I'm kind of curious to see what's going on in February 2023 visa bulletin edition. Let's see, February. And for everyone who's watching this video, this is the one easy way to kind of switch between the visa bulletins. If you want to take a look at the previous visa bulletin editions, just type in here in the link the year, if you're changing the year right here, and then a month and the year here, and it will come up right away. So here's February 2023. Let's take a look at the graph A again. Okay, so back in February it was still current. That's why. Yes, it's a little bit, well, not a little bit, it's kind of sad to see this really big retrogression. Hopefully we will see some positive movement in the next few months. We will see, again, that's what I was saying in the previous videos, in the previous visa bulletin editions, but haven't been anything good. I really don't know why it retrogressed that bad. Can't, unfortunately, tell you that, but the only thing we can do is monitor the visa bulletin, the new editions, and see where it is going. But as of right now, Sujan, about 4 more years for the availability of the immigrant visa. Okay, moving further to the next question comment from Chrysler for DGM. Thank you for your service. You're very welcome. I'm on green card and applied for my wife. We are at F2A right now. Our priority date is September 2019 and our case is documentarily complete since January 2023. We are waiting for a visa interview at Abu Dhabi. I'm confused. When should we get an interview? Does that mean we have 2 more years until we get an interview? Also, I'm about to become a citizen too. Would that help to expedite the process in any way? Thanks again. Chrysler for DGM, thank you very much for your comment, for your question. Really appreciate it. So yes, as of right now, you're correct. Judging by what we have on the visa bulletin, the most recent one, you have about 2 more years before the availability of the immigrant visa. Once your priority date becomes current on the visa bulletin, only after then the US Embassy schedules the interview for the immigrant visa. However, since you are in the process of becoming a US citizen and you're really close to that, yes, that might help quite a lot, because once you become the US citizen, it will the petition will upgrade from F2A, the second family preference category, to immediate relative category. Now it can be conditional resident because if you haven't been married more than 2 years, but it doesn't really matter. Still, the whole case upgrades to immediate relative category, and the immigrant visa becomes immediately available. And since the case has been already documentarily qualified, at that point you're just waiting for administrative processing, basically to for your interview to be scheduled. So with that being said, since you have about 2 more years, if you become in the next 6 months, you become citizen. Once you become the citizen, immediately send the notification to NVC and let them know that they need to switch and upgrade the case, and that's really it. It becomes basically current immediately, although there's for nothing, there isn't anything to become current now, because like I said, for immediate relatives the immigrant visa becomes immediately available. Okay, so let me pause the response here, and we're gonna move on to the next question coming from Sonimat Wani 662. Why F2B retrogress in September visa bulletin? So I don't think we have the September visa bulletin out yet. Let me check. Let me see what's going on the visa bulletin. So we don't have the September visa bulletin out just yet. On August visa bulletin, F2B is September 15. Let's see what we have on the previous one for July, because I'm pretty sure it did not move at all. Let's see. September 15. So I am not sure, Sony, where you're getting your information, because the official September 2023 visa bulletin did not come out yet. So I'm not sure where you're getting that information from. Hopefully it's not correct, because it would be really sad to see now F2B retrogressing, because we already seen the F2A retrogressing. Honestly, it kind of makes sense. So if you do have some kind of insider information, hey, let us know. I would really appreciate it. I'll definitely take a look into that, and that goes for everyone. If you're watching this video and if you have some kind of details or something that is not posted on the official sources, which is very rare, because most of the stuff that you have on the internet, on the forums or whatever, it's either from the official sources, or it is something that somebody just try to make a clickbait or something along those lines out of it. So Sonny, let me know to answer now if it really did retrogress. I personally cannot tell you why it did retrogress. A lot of retrogression that we see, of course, has to do with the backlog accumulation during the times of pandemic that we had. And we had closures for about 2 years. The immigrant visas were not issued at all. The US embassies were closed. So that, of course, added quite a lot. But the thing is, we consistently keep seeing that retrogression happening in the visa bulletin. And I mean, for how long can we really blame the pandemic, the situation with pandemic? I don't know. It's been quite a long time ago. It's been what is it, over 2 years ago now. But we still see that accumulation of the backlog, and it, honestly, to me, doesn't make sense. I wish I could answer that and tell you why we're seeing it. What I do is sometimes, I do news updates basically on this channel. And again, this is not really anything news out of something, that you wouldn't be able to find yourself from the official government sources, like USCIS and the Department of State. But sometimes, I think it's like once every few months, a representative from some kind of immigration attorney association of the US, they meet with the representative from the Department of State and they ask questions. Unfortunately, most of the times, whenever it comes to visa bulletin and family preference categories, most of the times it's very generic questions and very generic answers that don't really provide any kind of information. But I am hoping, and again, don't take my word for it, because I was hoping that we see some positive movement on the visa bulletins for June, July, August, but that's not the case. We're seeing bad stuff. But with all that bad stuff that we're seeing, I'm really hoping that somebody from that attorney association of immigration lawyers or whatever the hell, they actually ask a good, reasonable question on why we are seeing this backlog from that representative of the Department of State, and we will get a decent answer. But as of right now, there isn't really much that I can add to that. Okay, let's move on to the next question, comment from Sunrise. GP3OM, Sunrise, thank you for another comment. As always, appreciate them. I need to explain about household, which is my parents, and I living in the same place, and my mom, the petitioner for my brother, overseas. That means we are 3, right? Okay, so if it's your father and you, I guess. I'm not sure, Sunrise. I'm not sure if I understand your living situation. So you're saying your parents and you living in the same place. So maybe I'm not sure. Maybe your stepmom. But yes, if it's 3 people in the household, it's going to be the household of 3. As you said, I am the only one. Have to file I-864, right? Thanks again. Okay, so I-864A is the contract between the household members. Basically, if the main sponsor who is on the petition, if their personal income, right, that they have, is not enough to support the the immigrant that they're petitioning for, the alien relative, then they can make this I-864A, which is a contract between the household members, where you are showing that you are willing to basically add your income to the income of the sponsor so that it is enough to petition for. So it's kind of a unique case. If this is the situation, then yes, absolutely. If you are also willing to basically help, if you're here in the United States and if you're willing to add your income to the income of the sponsor in order to be a successful sponsor for the alien relative, then yes, I-864A is what you will be filling out. Okay, let's move on to the next question, comment from Kaika Roberts. 1215. Hi, my priority date is 26 March 2009. I was documentarily qualified a couple of days ago. Congratulations. Awesome. How soon do you think will my interview will be? I am from Antigua, the Caribbean. Okay, so Kaika, thank you very much for your comment. So what I'm really gonna need from you to know to answer your question is your family preference category. Since you're waiting from 2009 and you're just now becoming documentarily qualified, which is, the NVC portal should have been opening up as of recently. So let's take a look and see the Visa Bulletin 10. So there's a couple of things that might work. March 2010 and you're 2009. I think you might be in F3 category. You're definitely on all chargeability area, but I'm thinking you're F3 and January 2009 and you are March 2009. If you are in F3 category, and correct me if I'm wrong, let me know what your category is, but just looking at the dates and looking at the Visa Bulletin, it seems to me that you might be in F3. If it's not, let me know and I will provide the follow-up information. Just make sure, and it goes for everyone, if you are responding to my comment or a request for information or anything like that, make sure to post it as a separate comment. Don't respond to my comment within your comment, because then I don't see it. That YouTube does not send me notification for those. But Kaika, if you are F3, judging by the graph A now, final action dates, the priority dates are current for January 2009 that are becoming current as of right now, August 2023, and you are in March 2009. So it means that you are roughly 3-4 months away from the availability of the immigrant visa. Once the immigrant visa becomes available, the US Embassy schedules the interview, which can take some time before it is scheduled. So there's probably, you're probably looking overall, if this is, if my guesswork is close enough, you are probably looking at the end of this year, more likely beginning of 2024 for the interview. But again, let me know if this is not F3, and we will take a look at the visa bulletin again, and I'll let you know a little bit. Still rough estimates, but a little bit better. Okay, let's move on. From Sunrise again. Sunrise says, thank you again for answering. God bless you for help. Thank you, Sunrise. Appreciate it. God bless. My question is, what's the difference between preparing and interpreting? Which one I have to put my name because I helping my mom? Okay, Sunrise. So you don't have to worry about that at all. So whenever it comes to preparing and interpreting, these are actual services. If you have somebody, a third party, who helped you with the application, and a lot of times preparing, they do have like these kind of like notary services, whatever, document services where somebody who is familiar with the immigration procedure, but not an attorney, they actually help you prepare. Sometimes an attorney helps prepare, so they put their name in there. Whenever it comes to interpreting, a lot of times this has to do with translation services. So again, if you have a third party helping, kind of interpreting, the applicant is still filling it out themselves, but somebody is sitting there and translating some of the things, explaining what it is that it is interpreting. But in your situation, you don't have to worry about that because you're family. And that goes for everyone. If you are helping out your family member, and a lot of times, even if you're just helping out a friend, you don't have to worry about putting your name as a preparer or interpreter because you're not providing a service. This is only for people that are actually providing the service. Okay, let me post a response and move on to the next one. Looks like a couple comments from Prince Osei Bonsu 31. I have a B1, B2 visa, 5 years, multiple entry. How often can I visit the USA? I visited on May for my sister graduation and return on June. And I want to visit again in September or October because I have my annual leave. Prince Osei Bonsu, thank you very much for the comment. It's a great question. So whenever it comes to B1, B2, there are no restrictions. As long as you have your valid visa, that's it. You can come here as many times as you want. With that being said, keep in mind that the more often you come, the more, the longer you stay here, there is more chance, a possibility for unusual questions from CBP, right? Related to your entries that are frequent, that are prolonged, so far, so forth. And I know you didn't really stay here for that long, but in your situation, we're talking about the frequency. So when you come in, obviously expect, from the CBP officer asking, hey, you just been here in whatever, May, and you're coming back again in September. What's the reason for your visit? In your situation, you don't have any problems explaining, you're explaining, I'm on leave and I came to visit my sister or so far, so forth. And, I was back here in May for her graduation. That's it. It's all good reasons. So there shouldn't be any problems. There are no restrictions. But again, for everybody else who's watching, whenever it comes to B1, B2, if it's too frequent and you really don't have good reasoning, if it's just, I came as a tourist. Okay, and then 3 months later you come in as a tourist again to, so it looks starts to look a little bit suspicious in the eyes of the CBP officer that is sitting in the airport, that is, or port of entry in general. So keep that in mind, but in your situation, Prince, no problems at all. You have good reasoning, so there shouldn't be any issues. Okay, so let me post the response on both of your comments. And we're gonna move on to the next one from Grace X9797. I am applying for an L visa. Do I need to enter NA on the other classifications that don't apply to me? Grace X, thank you very much for the question. That's a great question. So the reason why it is a great question is because whenever it comes to paper applications that you're sending, as a package, as an application package to USCIS, I always say it's very important. It's a common rule that a lot of people do not know. Do not leave blank spaces. If it's a blank space, if it's not applicable to you, fill it out with N/A, not applicable, or none. But I prefer not applicable just so that they don't confuse none with, like, for example, if you don't have a middle name, don't put none in there because they might think that your middle name is none. Put not applicable. But the only exception to that rule is that I-129, because if you look at the I-129 application, it has the application itself, then it has the classifications, and you have to select one of the classifications basically that you're petitioning your non-immigrant worker to be in. All right, so there's L, there's P, there's O, there's a whole bunch of them. That is the only exception where you don't have to go on the application itself. Yes, don't leave any blank spaces, fill them out with not applicable. But all those qualifications that do not apply to you, you don't have to worry about them. You can leave them blank. You don't have to go through all of those pages filling them not applicable, not applicable. It would be crazy. But that's really the only exception. Okay, let me post a response here and we're gonna move on to the next question, comment. Looks like there are two from Ria Sithu, K22WH. And I live in India. Okay, so let's start with this one. Hi, kindly answer my question. Is my file applied by my husband, I-130, in April, month 27, so I'm assuming this year, and my husband lives in America. Please tell how many processing timing for I-130 to my interview, visa approval. I miss my husband so much. Ria, I completely understand. I'm not, not waiting to meet with a husband, but I'm waiting to meet with a brother. So it's much longer that waiting to reunite with a spouse. So I can definitely relate. I do have the family petition myself in process. Whenever it comes to the processing times, there's a lot of factors that gonna play a role. Because the application, if I understand, if it was submitted in 2023, because it is recent, most likely it is. It might be. If it's in April, so what is it? April. End of April, so May, June, July, and the beginning of August, so only 3 months. Most likely it is still with USCIS, and whenever it comes to the USCIS processing times, you will be checking there, and I'll show you where to start. So this is the official government website for USCIS, US Citizenship and Immigration Services, uscis.gov. We're gonna go to Tools right here at the very top of the navigation menu. And then from here, we're going to go to Case Status Online. And Ria, you should have the receipt number, or your husband, he should have the receipt number that he received after sending the I-130. He can enter the receipt number here and it will tell him in which stage of the process the case is in. But we're going to go to the processing times right here at the bottom of the page. And we're going to select the form I-130. Category. Now this is gonna play a huge role on the processing time and how long it will take. Is if your husband is a permanent resident or if he is a US citizen. So we're gonna start with permanent resident. There you go, permanent resident filing for a spouse, child, and then depending on which service center, I'll do all field offices, so it gives us the average 37 months. Quite a long time. That's a little bit over than 3 years. If your husband is a US citizen, then we got a little bit over 2 years. Still a long time, but definitely better than the previous one. Another thing that you have to keep in mind, if your husband is a permanent resident, then you are dealing with the visa backlog. Then you are in F2A category, and it's quite a long wait right now for the F2A. If your husband is a US citizen, you are in immediate relative category, which means that once your I-130 is approved by USCIS, your immigrant visa is immediately available. It does not mean that you will get it immediately because you still have to wait for all the administrative processing that is involved, but definitely much better than waiting all these years that people wait in family preference categories. So let me know, Ria, if you can. It would be definitely helpful to know more details. Again, the category would be helpful. Status of, or you can tell me the status of your husband, the priority date, when the if it was 2023 or if it was some other year, and I will get back to you and give you more details if I can. Okay, let's move on to the next question coming from so Skyboss Music 8686. Hi, I just subscribed. Thank you very much. And thank you for being publicly subscribed. This is what the icon means. I appreciate that quite a lot. Moving further to Prince of Say Bonsu once again. Thank you very for the work you're doing. God bless you. Thank you. Appreciate your kind words. I have a 5-year multiple entry B1 visa and I visited the USA. May for my sister's graduation trip. I want to visit again September, October because I have my annual leave. Will I face any problems with CBP at the airport or any advice for me? Alright, so that was already answered. I'm gonna post the answer here and we're gonna move on to the next question from Kaika Roberts. Once again, how long after I'm documentarily qualified will I have to wait for interview? So Kaika, I already responded to that. I think I might have requested additional information. So let me know and I will definitely get back to you. Okay, moving further to Ted Murray 711. Good day. Is the priority date for F1 family category worldwide date going to move this month? I'm hoping for more movement. Ted, yes, absolutely. I definitely share those hopes. I mean, F1, it's all of the family preference categories. You can't really look at one specific family preference category and say, well, this one deserves to do better than this one or any other one, because F1 is unmarried sons and daughters of U.S. citizen. U.S. citizen. Why does U.S. citizen have to wait for 8 years as of right now? 8 years to see their son or daughter who are unmarried. So they don't have their own families. They are just by themselves in another country. It's ridiculous. Or F2A, spouses and children under 21 of permanent residents. Think about that. Permanent resident. So this person already went through interviews. This person went through medical examination, through background checks. He or she paid a bunch of fees, probably a bunch of attorney fees, bunch of USCIS fees. And now they're a permanent resident. They did everything the right way. They did everything legally. Why is it that they have to wait for their spouse or their children under 21 for 6 years as of right now? It's ridiculous. Or unmarried sons and daughters, 21 or older, of permanent residents. Again, unmarried. They don't have their own families. They have to wait for, as of right now, 8 years. F3, married sons and daughters of U.S. citizens. Okay, well, at least they have their families. A little bit better. But still, of U.S. citizens. Look at how long they have to wait. 12 years. No, wait, my math is horrible. 14 years. 14 years as of right now they have to wait. And then, of course, brothers and sisters of U.S. citizens. 16 years as of right now. It's ridiculous. It really is ridiculous. And yeah, absolutely. When I see any kind of movement that is positive, I'm really happy. I'm really happy because movement in other categories, it kind of gives hope for the rest of the categories as well. You see the movement there and you're like, okay, well, that one is moving. So the immigrant visas are available, they are being issued, so I should be seeing some movement in my category as well. Will we now see the movement in September 2023 Visa Bulletin Edition? I don't know. Honestly, this past few months has not been very good. F1 was not doing too bad. F1 did pretty good. On the graph B, I think there was some movement for the F1. There was quite few months movement. I don't remember exactly how much, but again, I do have the videos where I compare the visa bulletins, and once the September comes out, I'll definitely make a comparison between the August and September. But to be completely honest, Ted, I have no idea. The visa bulletin has just been completely unpredictable. So we will see. We will see what's going to happen. From WA5D, amazing video. Appreciate your kind words, WFAD. Let's do another question, comment from Dedontobelli 9362. I applied in 2017 and am yet to get an interview. Still don't understand why this can be long. So you commented on the Asylum. Okay. Applied in 2017. So looks like you fell into that group, not the fell, but you were placed into the group of the asylum applicants that are waiting for longer time rather than those that are being processed now and they only wait like few weeks. It's completely unfair. I know it's dumb. Whoever made this decision is a very, very silly person. Let's just say that. But on the plus side, you do have an option. If the decision comes out after the interview, if it's not a positive decision, you do have an option, because you are in the group that waited a long time, you do have an option to take this case to the court, to the immigration court, and it's much higher chance of getting your asylum granted through an immigration court rather than through one of the asylum offices of, executive branch of the USCIS. So with that being said, it's, yes, you're waiting, but you have kind of a backup option just in case. People that are not waiting for their interviews and who submitted the application recently and got their interviews immediately, like weeks later, they don't have an option to take it to court. So if it is denied, then, well, it's not very... honestly, I don't know whose decision it was to make it so, but that's how it is as of right now. At least, yes, you're waiting. Yes, you're in the limbo, and I've seen a lot of cases like this, and I completely understand it can be frustrating. But you can legally work in the United States. You still have the valid status of pending asylum. Yes, it's not actually a status, but you are legally in the United States of America. And once you do have your interview, even if it's not positive response, you have an option to take it to court and get that asylum granted through court. So hopefully that helps you look at it a little bit from more from the positive side. And very last comment for today from Joanne Green 8474. You did an excellent job explaining. Joanne, thank you very much for your kind comment. Appreciate that quite a lot. So thank you very much, everyone, for tuning in today. Hopefully my answers were helpful. If you have any follow-up questions, comments, let me know in the comments below. And as many questions, as many comments you have, you're all welcome to post them here. Again, just make sure not to post them under my comment, because YouTube does not send me those comments for some reason. On this wall they don't show up. Just post it as a separate comment under any of the videos and it will come up here. So thanks again for your time. God bless, and I'll see you all in the next video.